Please permit me to put that question to you then.
Thank you.
What we need, will it be an alteration, or should we actually be looking at a sovereign national conference, which some people have put forward as the option, as the right option?
Now, I'm not going to scare any person by dealing with that question directly, because many persons have become scared, unnecessarily so. I'm going to endeavor to, give the explanations as they are, so that the decision will be ours whether indeed we need this, religious, very rigorous exercise of altering what we don't need, what we never had. You see, I opened the 1979 Constitution, which I have here.
It seems you are running away from my question, because it's about what we need.
Okay, if you need
a direct answer, because a lot of people are wondering.
We need a brand new Constitution. It does not come by way of alteration or by amendment. Okay. The Constitution under Section 9, as we have it presently, so the same Section 9 in 1979 Constitution gives the power to the National Assembly to amend the Constitution. Quite a rigorous process, because like we practice written Constitution, unlike what obtains in some countries like Britain and so on and so forth. Therefore, the bigger question is, given the critical state of the Nigerian country today, where, if you like, a section of the country is at war. I say that because there are certain countries that are not as big as the northeast central region of Nigeria. We are talking of a country where we can no longer, for sure, say that there is a clear future for the youth. Therefore, the bigger question will be, is it to continue to amend the Constitution that we have all identified to be one of the major problems that we are facing today? The 1979 Constitution I opened is actually Decree 25. The same old mistake. And if you permit me, I will read what seems very shocking to me, which is exactly what happened in 1999, where we have actually Decree 24. The question of constitutional amendment cannot cure what we need as of today, which is full-blown, people's-driven constitution. And you don't do it by amendment or by altering the sections, just because, as of today, your president traveled for health reasons, could not transfer power to the vice president. You identify that and dealt with it in one full amendment. Tomorrow, it is that Boko Haram can take lives, at will. You come back and amend. Next tomorrow, it is another. No. We are saying that there is a striking difference between the question of validity and legitimacy in constitution making. The one appeals to the authority, if you like, the power of whoever is implementing it. And that is the validity of the Constitution. That does not go too far. That is what we have. The major, most important aspect of any constitution is its legitimacy. You can only identify that from the contributory, the participatory value of the targets of that constitution.
If you permit me, let me
Would you like me to read that section? That scary section.
We'll take it in a few. We'll take it. Yes. Let's put that question to Senior Advocate Mr. Adesina.
Yes.
Now, in terms of what we need, if we are to look at our constitution today, Mr. Ugwummadu has said that it looks like just rubbing the surface of a serious injury and saying it's going to be fine. But if we have to look at the depth of it, do we begin to look at sovereign national conference? And if that's not the solution, what's the solution?
Thank you very much. I hope at the end of this program, we'll be able to persuade Nigerians that we cannot continue to technically avoid our problems as we are doing now. What we're doing today is avoiding our problems. there is no amount of amendment or alterations that you will carry out in 1999 Constitution that will make it a people-driven constitution. There is no amendment that we made that will confer on it popular legitimacy. What 1999 enjoys is a legal legitimacy by virtue of Decree 24 of 1999, promulgated by Abubakar military regime. And there was a section in that decree that says that by the time this schedule, in fact, the constitution was a schedule to a decree, that when you are operating this schedule, you can delete the decree. It's a deceit. What gave that constitution legal legitimacy was the decree, not the people of Nigeria. A constitution must be able to enjoy popular acceptability. 1999 does not. The making must be people-driven. People must make contributions at village, town, city levels, civil society organizations, professional bodies, labor unions, students, market men and women must make inputs. And then on top of it all, there must be a referendum that will give it the sanction that this is what we have given to us as a constitution, or given to ourselves as a constitution. Chief Williams,
people of Nigeria.
Yes, Chief Williams, FRA Williams, SAN of blessed memory, was an acknowledged constitutional lawyer in this country before he died. He was the first to describe 1999 Constitution as a document that tells lie against itself. That it was not made by the people of Nigeria. And before you can say a document has been made by the people must sit down and talk. They must disagree with themselves in order to come to an agreement. They must debate a product.
So while you're talking about that, can I quickly chip in this question?
Go ahead.
What is the fear of some parts of this nation about the issue of sovereign national
Thank you very
conference?
much. It is the fear of the unknown. But you have to confront that fear. Fear is a bondage. It has held this country into bondage for a very long time. We must all have faith, which is the direct opposite of fear, that things can work for us at least once. If you are afraid that you might be attacked, you won't go out. You will lock yourself in the house. The fear of Nigeria, that Nigeria will break up if we gather together to discuss our affairs, is unfounded. There is no Nigerian today, educated or illiterate, who does not know the value of size in terms of market, in terms of economy, in terms of opportunities. We all know this. And even if at the end of the day, in the unlikelihood event that we don't want to go on together, if that is the mutual consensus of all the debaters, so be it. There are countries that are smaller than just a section of this country all over the world, quite many. But I don't believe that Nigerians want to disintegrate. I don't believe they want to separate. Allow people to discuss. And let me also address this fear, because it has given me concerns. It is not compulsory that this body should be tagged Sovereign National Conference. You can call it a sovereign, you can call it a national conference. You can call it a national dialogue, but let there be a consciously organized forum for people to air their views with representatives from all sections and sectors of the society. Discussion itself, the mere fact that we are having this, is giving you confidence that things can work. I'll give you an example. In 2005, the then President of Federal Republic of Nigeria, Chief Olusegun Obasanjo, convocated the National Political Reform Conference. The name Sovereign was not part of it. That was a conference that some of us who were young there described as an assembly of both those who caused the problems of Nigeria, those who are the victims of the consequences of those problems, and those who are passionately looking out for solutions. Everybody was there. At the end of the day, corruption, security, economy, judiciary, and so on and so forth were addressed. I was a member of that conference. I was a member of the drafting committee of that conference. I was a member of the legal and judicial committee of the conference. And I know, as at that time, we had agreed that the office of the Attorney General and the Minister of Justice be separated in order to clothe that office of Attorney General with, with constitutional autonomy and powers to confront anybody. And nobody ever thought that a serving Attorney General will support that view. We had that in the current serving Attorney General of the Federation. I read his views in the papers, and I was pleasantly surprised. Because ironically, an Attorney General who was a senior colleague, who was a member of our committee, supported the view. But shortly after I was appointed Attorney General and Minister of Justice, he said it's not workable. So that a serving officer is supporting it now means we are shifting to face the realities of our problems, of our situations. So we need this thing. But now, lastly, please, because I'm very passionate about it. No amount of review, no amount of amendments or alterations will solve the problem. Like Malachy has said, the jamboree that is going on cannot achieve that purpose. When you amend, you are deleting and adding, and that amendment or deletion must not be holistic so as to make the original document worthless. Immediately you are getting beyond a percentage of about 35% upward. You are no longer amending. You are substituting, you are replacing. The National Assembly does not have the power to replace a constitution.